Okay, good afternoon, everyone. Back for the Wednesday afternoon session. This afternoon, we are with Ryland Ash, Managing Partner of Silver Shemmings Ash, and we are talking about payment disputes in construction, which is a continuing problem in the industry. So without any further ado, I will hand over to Ryland. Don't forget, if you have any questions, we're happy to answer these at the end. Use the Q&A panel, which is in the bottom toolbar for you. We'll get those questions queued up and Ryland will answer them at the end of his presentation. So Ryland, it's over to you.
Julie, thank you very much and good evening, everybody. So today's seminar is about payment disputes in the construction industry, and clearly in today's environment, this is going to be a big issue facing everybody day to day. So I'm going to give you an overview of the case law and the principles, and then I'll give you some examples in relation to the coronavirus, and we'll look at how you should be tackling these issues of getting paid at this time. So for those of you who haven't been to my seminars before, my background was as a barrister originally. I then moved to Southeast Asia to work on a large project there, and then came back to the UK to focus on construction disputes, drafting of contracts, and commercial advice more broadly, and of course seminars. So the first thing to look at in terms of payment disputes is whether or not there's a contract. Now that may sound obvious, but you'd be surprised about the number of cases that I see day to day in which the parties think they're in contract on particular terms, and it transpires that actually they're not. They may not be in contract at all, or they may be in contract on terms that they didn't think that they had engaged upon. Now, to answer the first part of that question, whether or not there is in fact a contract, one must apply the tests in law to the circumstances. And the tests are whether or not there is all of the essential ingredients for a contract. So offer, acceptance, consideration, an intention to be legally bound, and then terms and conditions ideally. So you're looking for all the essential terms, and there'll be the scope, the price, and hopefully some sort of provisions in terms of timeframes. And if you've got all of those ingredients, then it's likely that you've got a contract. Now, why do I say sometimes parties find out that they've engaged on terms that they didn't think that they'd engaged? Well, what often happens is during the contract negotiation phase, parties exchange offers and counter offers. So there may be an offer and then another offer is made, or a change to that offer is sent back. You might have an order or order acknowledgement that's then issued. Ultimately, the rules are that it's the last document, the last shot principle as it's known, which will apply before the contract is created. And a contract can be created or accepted, terms can be accepted by conduct alone. So you can find yourself being bound by terms and conditions just because they've been shot back to you at the 11th hour before the works began, and you haven't signed anything, but ultimately you'll be bound by those terms and conditions because they were the last shot. So I always say, do the opposite as you would do to maintain a healthy marriage or relationship. Try not to have the last word in your relationships, but in terms of contract formation, always have the last word. Now, in terms of the right to payment, as I say, that would depend upon whether or not you've got a contract. Assuming you have, the next question is, well, when am I entitled to be paid? Now, there's a whole raft of, there's hundreds of cases over the last few years, in particular in relation to construction matters that have got to the High Court, the Court of Appeal, and even the Supreme Court about when parties are to be paid. But the interesting point, I think, is that it's still good law in England and Wales that a party only gets paid for work, construction work, once that work is complete. That goes back to the 19th century and the principle that that a person has to complete the works before they're entitled to be paid, unless there's been an agreement otherwise. And in some cases, of course, there aren't. Now, the change over the years, the key change to that principle has been the introduction of the Construction Act. The Housing Grants Construction Regeneration Act 96, amended in 2011 by the Local Democracy Economic Development Construction Act. Long name, but we call them the Construction Acts. And what that did was introduce a right to interim payments, payments as you move along the job, which modifies this principle, which is still good law, that you only get paid when you're completing works. So what the courts have done is they've tried to apply the existing law to the new statute. So what they say is, well, you can only make an interim application. You can only get paid an interim sum on the dates that you've agreed. And if those dates are agreed, then they will apply. If those dates run out, for example, as a recent case involving Balfour Beatty, if you've got a schedule of dates and they expire, you're not entitled to any further interim payments. Now, of course, if that happens to be halfway through the job, then unfortunately, as a contractor or subcontractor, you're going to have to wait until the final account, or you're going to have to agree new terms with your client. So it's still a pretty hard and fast rule that you only get paid on the dates that you've agreed, or when the work is complete in any other circumstance. Now, most contracts that involve provisions that allow for interim payments will have provisions for applications for payment. So an application goes in by the person claiming money, the payee, and then that is to be assessed by the payer. But of course, some contracts specify the type of application or the nature of it, or the content, the form, and others don't. If they specify a particular form, then you're going to have to comply with that. And some contracts will even say, if you don't provide the information, the level of information that's required by the contract, then it won't be a valid application. And the courts are quite comfortable with that. They'll say, well, sorry, your entitlement doesn't apply until you follow the rules you've agreed in the contract. So the form and the detail required is important. If it doesn't state what should be contained within it, then ultimately there's a lot more flexibility available to you when you're making an application. And the application really should just show what you're claiming and the basis of calculation. And we'll come back to those things in a minute, because they're relevant to the validity of an application, equally to the validity of a payment notice and or a Payless notice, as we'll see later when we look at the case law in more detail on this. So what happens if there is no contract and you've still done work? Do you get paid? Well, I can tell you the answer is yes, you should. You have an entitlement to be paid. And that's because the common law, the English common law, comes to the rescue. And that doesn't mean, your mates from the pub come and bail you out. What that means is that the common law has developed over time principles which will protect a party that has provided some form of benefit to another party. So the principles of unjust enrichment, you can't be unjustly enriched by work that's been done for you, or unjust benefit. So you've had a benefit of somebody's work and you should be entitled to payment. The answer to the question as to how much you should be paid is that we go back to the wonderful roots of Roman law, and we look at quantum meruit, which is, again, another sort of common law doctrine, which says that you get paid as much as you deserve. That effectively means as much as you can prove. So if you are looking to make a claim on the basis of the common law, you have to make sure that your records are very good and that you can prove each and every amount that you are claiming. Excuse me. So that's the common law, and often those provisions and principles and rules will apply under a letter of intent, because it can often be argued that a letter of intent doesn't create a legally binding relationship, but it will very much depend upon the terms of that letter of intent. And the third point there is the statutory right, which I've mentioned, which comes from the, in the context of construction contracts, the Construction Act. Remember that the Construction Act will only apply to certain construction contracts. It excludes, for example, contracts with residential occupiers, people who are, doing extensions on their homes, for example. So if it's your home, then ultimately you're probably not bound by those provisions. But if you sign a contract that includes them, then obviously you are bound by them. And that's often the case, is that, a party, even with a residential occupier, will be based upon a contract that's been signed. The 45 days is flagged up there because even if you are caught by the Act, the interim payment entitlement will only kick in if your works are estimated to be for more than 45 days. And so that's the trigger, if you like, to the right to regular interim payments. So when we look at the Construction Act, what it says is that each construction contract must have an adequate mechanism for payment. So what that means is effectively that you must be able to determine what are the regular due dates and final date for payment. Now, often parties don't fully understand this, and I can appreciate that criticism, but the idea is that you have a date, which is the due date, upon which you value the works up to. And then you'll have a period after that due date, once you've calculated the sum due, to make payment in respect of that due date. And that's your final date for payment. And the idea of that is within that window, the payer can then issue a Payless Notice saying, actually, I'm not going to pay all of that amount. I'm going to pay you less because I'm deducting amounts under the contract for, let's say, defects or breaches of contract or delay damages. But the ingredients you're looking for is an application for payment. Whether or not there's a provision in the contract for an application for payment will depend upon the contract. If there are no provisions for applications for payment in a construction contract, then if a party applies for money, they can't rely upon that application as being a default notice, which will entitle them to payment. Basically, they have to sit back and wait for a certificate or payment notice to be issued because the application wouldn't be recognised under the contract or at law. The due date I've explained. Payment notice, the Construction Act is very specific about this. It says you must issue this notice within 5 days, no later than 5 days after the due date. And in some contracts, particularly ones that parties have created themselves or drafted themselves, I've seen provisions that allow for the issuing of a payment notice prior to the due date. I think that that's fine. I believe that there is authority. I've seen adjudication decisions in favour of that, saying that, well, as long as it's no later, that's what the statute says, so you can issue it no later than 5 days after the due date. But you have to, as we'll see later in the case law, specify that it is the value of the work up to the due date. That's the important part. And if you don't, then you risk it being an invalid notice. Now, the Payless Notice was introduced by the new Construction Act. Prior to that, we used to talk about withholding notices. Those of you remember the older JCT contracts. Withholding and Payless is different. Withholding used to be a concept whereby the amount due was established at the due date. And then if you wanted to set off against that amount, so you couldn't change the values in the certificate or the payment notice. But what you could do is you could set off against it contra charges or set off costs or counterclaims such as liquidated damages. Now, with the Payless Notice, you can effectively revalue the whole lot because of the way that the Construction Act is drafted. So effectively, payers, employers, and main contractors have 2 bites at the cherry, really, to value the works. You can value them at the payment notice, Or if you miss that, or you want to change your mind again, then you issue your Payless notice. And then you can go back to basics in relation to that notice. So that's very much in favour, if you like, of the payer. And then the final date for payment, well, that's the date by which the party to receive money should get it in their bank. Now, in terms of the contents of a Payless notice, as I said, there's some interesting recent case law on this. This mere construction case versus Capital Residential 2017 is actually a Scottish law case, but it did set the tone for a number of judgments that were then handed down in the English courts after this. And really, the principle that came out of this judgment was it needs to be reasonably clear from the document submitted what its intention is. And there's a test that should be applied, which is that of the reasonable recipient. If a reasonable recipient would have taken a Payless notice or a document that purports to be a Payless notice to be such a document, then the answer is it is. If it's unclear, if someone, for example, we'll see a contrary judgment, the Jawabi case coming on later, where somebody just marks up an application for payment and sends it back. If it's unclear like that, then it won't be considered a valid Payless notice. So this is the case that sort of set the trend in that regard. And it's all about the reasonable recipient. And what you really need is an explanation, a breakdown and detail of how you've got to the sum that is stated in your Payless notice. And of course, it has to be in time as well. And by in time, I mean by the last date that it can be issued. And the last date it can be issued is the final date for payment. The number of days that it should be issued prior to that will be determined by the contract. The JCT, for example, says 5 days prior to the final date. The scheme for construction contracts, which supplements the Construction Act, says 7 days prior, but you can agree anything up to sort of 1 day prior, or even the same day as the final date for payment. So that will very much depend on your contract. So you must set out the sum considered due and the basis on which it's calculated. That's the key thing. And in this case, the notice fell short of those requirements. The Payless notice must set out the grounds for withholding, which is again important, because sometimes you just see Payless notice with amounts in them. They don't explain why or on what grounds certain amounts have been deducted. And to each of the grounds, the amount that's being deducted. And at least an indication of how each of these sums have been arrived at. And if there isn't a reasonable breakdown or reasonable grounds or even genuine grounds, then there is potential for argument to say, actually, you know what, I don't think that this Payless notice is valid at all, which of course may then lead to the situation where the sum applied for is something that's an entitlement in full. The next thing to consider is a more general point about whether or not the other party understands what's being applied for. Quite often I see parties prepared to go into dispute and even go to court when they don't fully understand each other's position. And that's a big mistake, even from my perspective, because you don't want to be going to court with cases that can move and shift and change because costs escalate and it's difficult to predict those matters. So does the other party understand? Are there contractual requirements that you've satisfied? For example, if you're claiming for a variation, well, are you entitled to that variation? Is it a variation under the contract? If you're making a claim for an extension of time and prolongation, are you entitled to that money? Are there provisions for loss and expense that apply? So the style and substantiation points are key. Style is more about understanding. Substantiation is obviously proof. And the more proof and substantiation you can provide, the better. If a party doesn't provide good proof or substantiation, I'm a big fan of having commercial negotiations about these things. But if they can't resolve things, often a swift adjudication will. So There are different ways of resolving these types of problems. But ultimately, what you should be doing is trying to refine your arguments, trying to narrow the issues between the parties. And the only way you can do that is by analysing what's been claimed, what is the contractual or legal basis, is it correct, is the quantum correct, and then coming to your considered conclusions on that matter and the overall value implication of that. So what I'm doing here is I'm splitting in this slide the principles of entitlement to liability and quantum. And often that's a good way to separate out complex or big differences between parties in an account. So I suggest first thing you should do is, if you've got differences in an account, is probably prioritize the bigger value items, but then set the value aside and then deal with the principle first. So do you disagree in principle that it is an entitlement? Obviously, if you don't disagree, you agree that it's a change, for example, or it's a valid claim, then you move on to stage 2, which is the quantum. But if you don't agree, then obviously you need to try and resolve the issues of principle. So split the key differences between liability and quantum, and that will give you a framework from which to work with to try and narrow the issues between the parties. And of course, if you can't, will then form the basis of a framework for dispute resolution. In terms of quantum, it's important to distinguish value and cost. Value relates to the value that should be applied as agreed under your contract, not the value in the open market necessarily. It's the value to be applied as agreed under the contract. Cost should be a market rate, and it should be reasonable, it should be mitigated, and so there are very different concepts, and different contracts choose to value claims in different ways. The NEC contracts, for example, if you're familiar with them, will talk about entitlement to defined cost, which of course is a cost claim in that respect. And the JCT contracts, by comparison, unless you get down to fair market value in the valuation rules, which is the last one, the starting point is the contract. Under the contract, what was the value of these works? Are they similar? Can I apply the rates in the contract? If the conditions, excuse me, for the works are different, but the work's similar, I will uplift the rates in the contract, but I won't completely depart from what had been agreed. In other words, we're talking about value in most cases as opposed to cost. And that's an important distinction to make. Next, I wanted to look at variations. What do the provisions say in your contract about variations? Well, you start with, are there any provisions? If there are no provisions for variations, then you can't have variations. The parties can agree to make changes. And often if you don't have variation provisions, you get into complex arguments about whether or not the parties have agreed on an ongoing basis, case-by-case basis. But that's a very messy type of dispute, and it will be very costly to resolve. Ultimately, I mean, the straightforward position is, if you don't have variation provisions, you can't have variations under that contract. They shouldn't really be valued as variations. What effectively happens is if you make separate agreements in relation to what you're calling variations, and in other words, changes to the works, they can become new standalone agreements, new standalone contracts in their own right, which I think if you're listening to what I'm saying, you'll recognize could lead to a great deal of difficulty between the parties, and obviously trying to resolve, you know, multiple contract disputes is a mess. So if you have got variation provisions, then obviously you start with the definition of what a variation is, and we'll look at that in a moment in the JCT context. And you need to ensure that whatever you're claiming for fits that definition. And if it doesn't, then I'm afraid you won't be entitled to make a claim for such a variation unless you can get some form of agreement, as I say, separately. But if it is an agreement where there is no entitlement, obviously you need to be careful how you make that agreement, that it's clear and that you record it and that you can rely upon it later. In many cases, parties have been paid even on account for certain things that they consider to be variations, and then suddenly at the end of a job, a client can turn around and say, actually, I don't think any of those are variations because you haven't given me a site instruction or a signed instruction, or show me where in the contract that this is a variation. And they'll have an entitlement to open that back up. It's more difficult if they've made payments and assessed those amounts, because there'll be an argument about waiver and estoppel. These are things that prevent you from changing your position drastically. But if someone's been careful in valuing the work, saying, well, I'll pay these on account, you're not agreeing to the principles, you're just trying to be fair to a contractor or subcontractor, then bear in mind those amounts may be opened up later and may not be so useful when it comes to a final account assessment. When we talk about design development, I'm raising that because if you have design obligations, particularly under the JCT contract, you have an obligation to complete the design that's set out in the employer's requirements, which means that there is an inherent amount of design development that needs to be done. And that design development, to get to the point of construction drawings to be able to build to, is something that you have deemed to have priced in your lump sum or within your sum for your design allowance. So design development is not necessarily a variation. In fact, in most cases it isn't. If you think it's a variation, then what you're going to need to establish is whether or not it is in fact a change to the employer's requirements under the JCT, or if it's the NEC contract or another form of contract, changes to the original scope that have been instructed. But in a lot of cases, you'll find that design development, if you're a design and build contractor or subcontractor, is pretty much par for the course, and you've assumed the risk in relation to that design development to get it up to scratch so that it can be built. So the two main reasons why a variation may occur. Events external to the contract might dictate that you need to change things, or there's been straightforward changes in the design, the scope, or the circumstances. But be careful, because changes in circumstances or external events may not lead to a variation. It's a question of the definition of the variation in the contract, and as I say, applying the facts to that legal definition. A variation may also arise as a result of extra work, of course, or the method of construction. This might be a good time to mention the coronavirus. So those of you familiar with the other provisions of the JCT contract will know that there is a force majeure provision in the relevant events for an extension of time claim, but there is no force majeure provision in relation to relevant matters and loss and expense. It seems likely to me that the coronavirus is going to be deemed by the courts to be a force majeure event. But that doesn't help a contractor or subcontractor when they're looking to claim loss and expense under the JCT, because there's no right. However, it may be that the changing conditions on site are a variation nonetheless. And if they are, that would entitle a contractor under the JCT, at least, to seek to recover both an extension of time and loss and expense, because a variation is both a relevant event and a relevant matter. As I've said, for a variation to occur, it must mean that there's a mechanism to allow it, and it must permit a variation under the contract rather than to the contract itself. There's a distinction there between a variation to the works that have been agreed under the contract and actually variations to the contract itself. At this point, I wanted to mention the case of Rock Advertising and MWB. This is a Supreme Court case from last year, I believe, where it was decided that if a contract includes a provision that says there cannot be an oral, verbal amendment made to this contract, then if you then subsequently come to a verbal agreement to amend the contract, that will not have any effect. And it's an important case because the judgments swung from one way to another. In the High Court, it was decided that that the provision was valid. You couldn't change the terms. Then in the Court of Appeal reversed that and said actually the freedom of the parties is effectively absolute and that they can change the agreement at any time. And then the Supreme Court reversed that and said no, if the parties have made a clear agreement saying that this is what is to apply to changes and we can't have any changes verbally, then I'm afraid you'll be bound by that provision. And in the same way, if you think about it, if a contract has a provision that says how variations will be valued, then I'm afraid that would stand as well, notwithstanding the fact the parties may have sought to agree otherwise. So one has to be careful particularly when there are verbal agreements to change or perhaps to value or agree a valuation. Often you'll have QS to QS meeting up on the other side of the table, making agreements in relation to values. They may not have an effect if your contract has provisions that prevent it. So I thought that was worth mentioning. When a contractor makes a claim for payment for extra work, the primary question to be asked is whether the work is included in the contract or does it in fact amount to a variation. In order to prove at common law, the contractor must prove work was extra over than that agreed at the original contract date. There was an express or implied promise to pay for it or a provision, and that any agent had authority to issue instructions. That's another point where you have parties that don't have any authority giving instructions to make changes which are then made, and then the party turns around and says, well, hang on a minute, I'm not paying you for those because that person never had the authority to give those instructions. The best way to avoid this situation is, of course, have from the outset in the agreement or somewhere recorded that certain people will have authority excuse me, to provide instructions. If they don't, or if you don't record that, then the answer will be in law that it is the person who has apparent or ostensible authority. So if it was reasonable for you to believe that the commercial director or the project manager on a job had authority to make changes, then I would say that was reasonable, that those people would have apparent or ostensible authority. But if it's somebody who's perhaps only administrative, then there may be questions over whether or not actually they ever had the authority to give those instructions. But obviously to avoid that, get it in your contract or record those instructions and get them signed by people at the appropriate level. So standard forms have express rules for dealing with such circumstances. In the JCT, one must consider in the JCT contract, one must consider, let's go back to that, the recitals, because they are the most important provisions, arguably. The conditions, of course, are important as well, but the agreement takes priority over the conditions. So anything in there is going to be essentially more important. And the second question is whether the variation goes to the root of the contract. A variation is to primarily deal with the unexpected rather than a consequence of poor planning or frequent changes of mind. And the case I've referred to is a cracking case of Walter Lilly versus Mackay, where Mr. Mackay wanted 4 terraced houses turned into, or renovated effectively, There were 4 contracts originally, and he then transferred all of the obligations, design and build, into one contract. There were all kinds of changes, and then he refused essentially to pay for any extension of time or loss and expense because he thought that the contractor had priced everything. The court wasn't very impressed with that argument and actually awarded the contractor substantial amounts for the extension of time and for the loss and expense. But there were comments made about variations, certain variations, to say that ultimately they're not there to make good any poor planning or frequent changes of mind. They may lead to breaches of contract or other entitlements. So looking at the JCT contract, variations under 5.1, we've got a good definition there. The alteration, modification of the design, quality or quantity of the works, including addition, omission or substitution of any work, and the kind or standard of any materials or goods. And it includes the imposition by the employer of a change to access. This is where I'm thinking of coronavirus, change to access, working space, working hours, or the order of execution. And, you know, with new public health recommendations and regulations, you can see how those provisions could be relevant. But look at the detailed wording and then apply it to your situation. By all means, take advice or send me an email, give me a call. In respect of the contractor's design portion, any instruction requiring variation shall be an alteration or modification to the employer's requirements. So that goes back to my point about design. There needs to be a change to the ERs, really, for there to be a variation. It's worth noting, under the JCT, you have a reasonable right of objection. Often that's taken out, which I think is totally unreasonable, but there you are. You know, that allows the contractor or subcontractor to essentially say, no, thank you. But it's a reasonable right of objection. So you can't just say, for example, you know, I've run out of resources, or I don't fancy doing that work. Ultimately, it has to really be a good reason, which would be it's outside of your expertise, for example, or here it talks about whether or not it would injuriously affect the efficacy of the design. Clearly, you know, if you're told to remove certain underpinning just to make a building look pretty, then you can object to something like that. Parties either parties either agree the value, I should say, they often argue, or the amount is valued in accordance with the valuation rules. And I touched on the valuation rules earlier, but they are essentially use the contract rates, adapt the contract rates, use day work rates, or use a fair value. And that's the JCT valuation rules in very short hand. Whether or not there's a disagreement over whether an item of work is variation, most commonly it will be the value of the variation that will cause the issue. Usually the argument is on the price and the effect of the program. The rules of valuation, if they apply, are mandatory. So if it's a JCT contract and you've got a variation and you can't agree it, what a third party will do is they will assess it on the basis of the agreed valuation rules. And obviously, if the valuation rules then need to be applied, then you would look to get the opinion of ideally a third party or an independent party in respect of the quantum and to say, you know, in their professional experience that the value to be attributed to that matter when applying the valuation rules should be X, Y, or Z. And that's how, under the JCT contract, those types of issues are resolved. In terms of the effect of the variation on the program, that is obviously under the JCT, it's considered to be a separate issue in that there are separate provisions for delays in the relevant events section of the contract. But my own view is that practically parties should be continually looking to link variations with the program. They should be continually updating the program, reflecting variations, showing the variations in the work on the program as new activities or extended activities, and setting out and trying to establish entitlement at that time. That's the best way to avoid more of a dispute, shall we say, later in respect of final or later valuations. So deal with them early. The JCT provisions in the later versions of the contracts do now have provisions for quotations for variations to be provided, and that can include a revised program. So a client or main contractor can say, I'm thinking about doing this variation. Can you quote for it? And can you tell me how it's going to impact upon the program? And then contractors and subcontractors can provide those prices, and everybody goes into things with their eyes open. I think that's the best way really to run a project, so that there are not too many surprises and disagreements later. Now, in terms of your remedies or your leverage, if you're not being paid, there's a number of things that you can do, but the one that stands out, first of all, is the 7-day notice of intention to suspend the works. This used to be a right to suspend the works for a failure to pay the sum due. And the problem with that was there could be disputes over what was the sum due. And so if you claimed an amount, you weren't paid, you sought to suspend, you do suspend, and then you ended up in a dispute over what was the sum due, and it turns out you weren't entitled to all the money you claimed. It could be said that you were in breach of contract for suspending wrongfully, because you had no right to do so. And that can lead to further arguments that you were in breach and that you're liable for damages and possibly rights of termination. But now it's all about the notified sum. So what that means is effectively, if there's a sum that's in an application for payment, a payment notice, a Payless notice, whichever is the last, or even a default notice, whichever is the last notice issued by the final date for payment, that will be the notified sum. And then there's a straightforward entitlement to that sum, which can't be then disputed effectively. It has to be paid, and then an argument could come out later, which I'll come back to in a moment. And you then have the right to issue this notice of an intention to suspend the works, and you can suspend all or part of the works, and you can also seek to recover your loss and expense. So that's your leverage in the first instance if you haven't been paid, if it's a notified sum. Before we go into these cases, your other remedies in relation to non-payment would include, of course, a dispute, dispute resolution, mediation could be considered if the parties are reasonably close or it's just a question of quantum. But if there are issues of principle and quantum, then I would rather recommend adjudication. They're very successful in terms of percentages of resolving disputes and them not going any further. But a number of these cases, ironically, that we're referring to relate to adjudications. But these cases here tend to relate more to the payment notice law, and when an entitlement arises to a smash and grab adjudication where there's been simply no Payless notice issued, or a default entitlement arises, and what the limitations are of that. So first of all, if we look at ISG and Seavich College going back to 14, there was an adjudication over whether or not it was a Payless notice, and it was decided that there wasn't, and therefore there was an entitlement to the full amount applied for. And in fact, in that case, the judgment refers to the principles I started off explaining, which were that under English law, you only get paid when you've completed your works. what happened in that case was that there was a second adjudication on the true value of the application for payment that had been decided as the default sum. And what the judge decided was, actually you can't do that. The value effectively has been decided because you didn't give a pay less notice. And as we'll see in a moment, that has sort of come in for some criticism over the years, and now effectively that position has been reversed, as we'll see, or certainly watered down fairly drastically. The Henia investment case, it was more about whether or not a payment valuation or payment notice was valid. And in all these cases, there seems to be a consistent theme, which is that parties start off agreeing certain dates to make applications and issue payment notices, and then they just disregard them and forget about them and issue them whenever they want, which obviously creates a problem. So if you can, stick to your dates. But ultimately, the courts decided in this one that the valuation or the application of the payment notice has to be free from ambiguity. And so if there is ambiguity around what the notice actually is it an application? Is it a payment notice or is it a payless notice? Then it will not be valid. And the courts also said that it was important, Justice Aikenhead said it was important that the parties claim the value of the work up to the due date. And it's important to note that if you issue a pay less notice, that the Construction Act says that it should be in respect of the sums that are payable or due on that date. In other words, the date that the notice is issued. So not necessarily the previous due date. So that's a nuanced point, a difference between payless notices and payment applications being in respect of the due date. But as long as they describe the value of the works up to the payment due date, then they should be valid. And as long as they've got a reasonable amount of breakdown explaining the sum that is payable, or if there's nothing payable, explain why with a breakdown. The Jawabi Properties and Interior Group's case essentially found that a payless notice had not been issued because what the client had issued was simply, the contract administrator had issued an application for payment with hand markups against each value. And that may seem a little harsh because I know that often parties do that, but ultimately it wasn't entirely clear that it was a payless notice. It may have been something for debate or discussion. So it's important again to look at what the reasonable recipient, going back to the mere Scottish case, would make of a notice. And it needs to be clear in form that what you're sending is a payment notice or a payless or whatever it might be. It doesn't necessarily have to state on it that what it is, but it should be saying, this is the amount due and payable, and this is the basis on which I've calculated it. There is also scope to refer to other documents that have been previously issued, or a breakdown that may have been previously issued when issuing a payment or payless notice. So you don't always have to reissue all of the breakdowns. It's acceptable to just make reference to another document that you may have produced previously in relation to an application. But obviously be careful if you're going to do that to make sure that it does give a full breakdown of the sum that you think is payable. So when I said that Sewich College had come into some criticism, that's as a result of this case here, Grove Developments and Balfour Beatty. So in this case, the parties agreed a schedule of payments for works up to the point of completion. Contractor did not complete in time. There was no agreement on payments post-completion. It was deemed reasonably foreseeable that the omission of any such provision would have had a commercially disadvantageous impact. interim payments were for any work under the construction contract, did not mean a party was entitled to interim payments for every single piece of work under the contract, and entitlement could only be realised at the agreed intervals specified in the contract. So the point in this case was that there was a schedule for interim payments that expired. And essentially the courts decided that once that schedule runs out, there's no other entitlement to interim payments. But it's important to remember in this case that the provisions in the JCT contract that were used included staged payments as opposed to periodic payments. So it may be the case, actually, that if you've got periodic payment provisions in your contract, there would have been a different outcome. And I suggest that they probably would be. That if you had periodic payments, then arguably they should continue once the schedule's finished. But that may be a difficult argument to run in the face of this case. And ultimately, the moral of the story there is that you need to make sure that your scheduled dates cover a reasonable extension to the program, and also have provisions in there that say that they'll continue on the same dates thereafter up until practical completion, or to the end of the rectification period, if you like, up to the issue of the final certificate. And then again, another Grove Developments case, but in this one with S&T, and this is the one really that I would suggest effectively reversed ISG and Seavich, and the right to a smash and grab adjudication was diluted. So in this case, it was a single judgment ruling that the employer was able to challenge the amount due to the contractor as a result of a smash and grab, even though there was no valid payment and/or pay less notice. In his judgment, Lord Justice Coulson expressed dissatisfaction. This was his final judgment as a High Court judge. So he really left a legacy there before he moved up to the Court of Appeal, saying, "I believe that my conclusions will strengthen the system because it will reduce the number of smash and grab adjudications, which in my view have brought adjudication into a certain amount of disrepute." So the idea of smash and grab adjudications lives on, but it's certainly been watered down in the sense that in this judgment, it was decided that you could also, subsequent to the smash and grab argument, look at the true merits of the same valuation. But that's not quite the end of the story. If you look at the conclusions reached, they'll be most interesting, obviously, to you guys representing a change of approach. And Lord Justice Coulson has obviously concluded that a payless notice was effective. Had a payless notice was effective, Grove were not allowed, not obliged to pay the sum stated as due. There'd be no requirement for the issue to be considered. However, the judge took the opportunity to set out his detailed analysis, and in doing so, made clear, though not necessary to this case, his comments were not obiter. So what Justice Coulson was making clear is that the employer can commence a second adjudication to seek the true value of the sum due, where it's failed to pay the notice. And these are the reasons why. He thought that as a matter of equality and fairness, that the ability to adjudicate the true value must be balanced with the entitlement of the contractor to do likewise. And it would be wrong to prohibit the employer from doing what the contractor can do. And there's no justification for the previous authorities that distinguish the employer's ability to adjudicate. There's a final application as opposed to an interim application. There's no distinction in the JCT form. There's no difference between the payment rights and the obligations in respect of interim and the final payment. So following these conclusions, he was considering the previous judgments and reluctantly disagreed with the approach in Seavich College and Galliford Try and Estura, which followed it. But the important point here, ladies and gents, is that if there is an entitlement to a smash and grab, and you do want to run an argument on the true value subsequently, bear in mind that you are likely to have to pay the smash and grab value first, and then seek to pursue the true value dispute. You must make sure that you satisfy the smash and grab first. Otherwise, the likelihood is the smash and grab might then get enforced. You have to pay the cost of that, and then you're back into another argument about the true value. If you're an employer or main contractor who has missed certain dates, or you think there's a risk that you have, better to adjudicate first on the true value and get in first. Then you could seek to enforce that, and that would counteract and avoid any smash and grab argument. And then even if they were heard together, which wouldn't happen if you got in first in enough time, then ultimately you would avoid having to pay first and argue later. But if you haven't done that, then I'm afraid you're going to have to pay first the smash and grab amount and then argue about the true value subsequently. And then the final case to mention here is, as you can see, if you can see the slides, is a 2020 case. And it's the first, I believe, the first case on the coronavirus, certainly the first one in the Technology and Construction Court. And in this case, there was an adjudication that was on foot at the beginning of the spreading of the pandemic. And the party who was referring was obviously seeking to proceed with the adjudication. The responding party sought to challenge the right to adjudicate by saying that it would be a breach of natural justice to bring an adjudication or force a party to respond to an adjudication during the lockdown, or at that time, just in the circumstances generally. And the courts heard the application for an injunction to prevent the adjudication, and the injunction was refused. The court said that it would only grant injunctive relief very rarely and in clear-cut cases, and that's following Lonsdale Electrical and Bresco. And in this case, the question was whether proceeding with the adjudication would result in a breach of natural justice to render it unenforceable, and the test applied had not been met. So therefore, ultimately, adjudications carry on come what may, and there are hearings going on every day online through the courts to enforce these rights. So that's a real enforcement that if you're owed money, do not hesitate because of the circumstances. You must pursue your rights. And in some ways, it's probably a better time than any as a referring party, because responding parties are going to be struggling to pull together information during this time. So in conclusion then, we started off with principles about whether or not you have a contract. Remember that they are fundamental, because you can't work out what you're entitled to unless you have an answer to that question. The next thing is what provisions are in that contract, and how do they apply to your factual circumstances. And the next thing is to look at what the entitlement comes from. Is it a variation? Is it a claim under other provisions of that contract? Obviously, proof is going to be crucial. Keeping records is fundamentally important to establish your rights. Remember the distinction between value and cost. If you're faced with delays and claims for the coronavirus, you can have a look at your provisions, and certainly I could take a look at them and we could consider whether or not there's entitlement there. It won't surprise you that that's been something that's taken up most of my time since the pandemic broke. And the key thing is that parties are looking to be sensible in a lot of cases. But if they're not, my advice would be is to pursue your money quickly, swiftly, and without hesitation, because the risk is likely that parties will go under, if not now or in the coming months. And if they can't pay you now, there's probably a good reason for it. So understand your rights, pursue your rights, and in the end, that should lead to you getting paid. Thank you all very much for listening. Julie's now popped up on my screen. So if you have any questions, please type them in, and I think she'll relay them to me and I'll try and answer them now for you. Otherwise, or in addition to that, if you want to send me emails, you should see my email address up there on the screen now.
Okay, well, we've got two questions here, Ryland. One says contracts. You mentioned 5 days. Is that 5 days or 5 working days?
That'd be calendar days under the JCT, but check your specific contract provisions. Sometimes there'll be amendments which will say that might be working days, but in most cases, under all the JCT standard forms, that's calendar days prior to the final date for payment.
Okay, and then second question, which has been sent, is material costs have increased considerably due to COVID-19. Conditions under which a contract are being executed have changed due to COVID-19. Is this a variation? So should the contractor be entitled to an extra to cover the additional cost? If the contractor waits for prices to reduce, he may be liable to damages for late completion.
Well, the answer is it depends on the specific wording of the contract. If you're just basing a claim upon the fact that the cost has gone up and you've already given a cost for those materials, then I'm afraid the risk is probably sat with the contractor or subcontractor. The only way probably around that is if you can argue that it's a result of a variation or it's a result of delay. So if it's extra work that needs to be done within the delay period, there may be an argument to say that within the delay period, your costs have gone up and therefore you could recover them. Because you should be entitled to any increase in the overrun period if you're entitled to loss and expense, for example. But you'd have to obviously establish that right in the first place. But I think that if it's just the case that the cost has gone up for something you'd already agreed, ultimately, I think you've probably accepted the risk on that. But I'd be happy to look at any contract provisions that relates to.
Okay, no problem. That's great. And I think we've got one in the chat box as well. Bear with me just one moment, Ryland. It's just come in. Oh, it sounds just to clarify, it's a material change.
Was that from the person raising the question?
No, it's from someone else. So would that be a material change?
Yeah, well, there's no mention of material change necessarily. It is not a question of whether it's material or not. It's a question of whether it fits the definition in the JCT of a variation. And if it's just increase in the cost to the contractor or subcontractor, as I say, it's likely to be their risk. But if it is something that forms part of a variation, then in that situation, you may have an argument to claim for the extra cost.
Okay, but as you say, if it's a specific issue that someone's dealing with, then you're happy to have a look at the specifics of that.
Yes, of course. Yeah.
Okay, well, thank you very much, everyone, for attending this evening, and we hope to see you again very soon. July dates are now available on the website. Please book as many as you like. It's always great to see you all virtually. And in the meantime, please stay safe. We'll see you all again soon. Thank you.
Thanks, Julie.
Thanks, Ryland.
Thanks, everybody.